Hello, this is Ran Guo from East China Normal University, Shanghai, China. It's my greatest honor to have my paper published on the Journal of East Asia and International Law. My paper deals with the Huangyan Island or Scarborough Shoal in the South China Sea. During the Sino-Philippine standoff in 2012, both parties issued official announcements in order to clarify their claims over the Huangyan Island, as well as the legal and factual basis. Both announcements suggested whether China or the Philippines owns the Huangyan Island depends on which party had sovereignty in 1946 and which party has exercised an effective occupation and jurisdiction over the island since 1946. Before 1946, China had acquired its territorial title over the Huangyan Island by discovery of terra nullius, or at least an inchoate title in Palmer's case standard with its discovery and occupation in the 13th century, which later had been consolidated into a full title with the historical consolidation process. Meanwhile, the Philippines had never claimed anything in this period that might compete with the manifestations of Chinese sovereignty. Instead, its treaties, constitutions, domestic laws confirm the Huangyan Island lies out of the territory. The Philippine evidence between 1946 and 1997, such as maps, flag-raising, military utilization, and scientific research, are either private in nature or contradictory to its domestic laws, governmental position, and international law on territorial acquisition, thus making its claims vulnerable. China further consolidated its territorial claim with evidence such as numerous official maps, various manifestations of the sovereignty, legislation, and official announcements, which are superior to those produced by the Philippines. Therefore, China had sufficiently exercised an open, continuous, and peaceful, effective occupation over the Huangyan Island in this period. On April 30, 1997, the Philippines made an open official claim over the territory of the Huangyan Island. It crystallized the dispute, so that that day is tentatively determined to be the critical date. According to the ICJ critical date doctrine, only those acts undertaken before April 30, 1997 can be adduced to prove the respective claims of the territorial sovereignty. No acts undertaken by either party after the critical date can alter the sovereignty ownership. If China has acquired and consolidated the island's territorial sovereignty before this critical date, China is entitled to hold territorial sovereignty over the Huangyan Island. Although I have tried to prove China's ownership of the Huangyan Island, it is more important for me to build up some common grounds for peaceful settlement of the problem in the future. For example, what is the character of this issue? What is the governing rule? What can be regarded as evidence? If we have found these common grounds, a peaceful settlement will not be far.